The first condolence card was still on the counter when I got the divorce papers. My name is David Mercer. I'm 48, and I've spent the last 22 years planning other people's estates at Meridian Trust in Chicago. I know how families fall apart when money gets involved. I just never thought mine would be next. The envelope sat beside my father's funeral program. Clean white paper, legal letterhead, Susan's signature at the bottom of a petition that read like a business transaction. She'd highlighted one line in yellow: I am entitled to half of all marital and inherited assets. No phone call, no conversation. Just the lawyer's envelope doing the talking for her. I set the papers down beside the sympathy cards. Didn't call back. Didn't cry either. 24 hours ago, I'd buried my father in Graceland Cemetery. Susan wore black, held my arm during the service, accepted condolences from neighbors who'd known us for 15 years. Now she wanted half of everything he'd left behind. The irony wasn't lost on me. In my line of work, I'd seen this script before. Grief makes people do strange things. But greed? That's just Tuesday at the office. I walked through our empty house. Her clothes were gone, closet cleared out, even her coffee mug had disappeared from the kitchen sink. She'd planned this down to the last detail. But here's the thing about planning. It only works when you understand all the variables. The past 6 months replayed in my head like security footage. My father's final decline, the hospital visits, the long nights watching him fade. Susan had her reasons for staying away. It's too hard watching him like this, David. I can't handle seeing him so weak. I didn't push. Grief hits everyone differently, right? I remembered the missing watch now. Dad's old Timex, the one he'd worn to work for 30 years. I'd noticed it was gone during one of my visits, but he waved it off when I asked. Susan helped me with some bank appointments, he'd said. Good to have someone you trust handle the details. Trust. That word felt different now. I poured myself a scotch and sat at the kitchen table, the divorce papers spread out in front of me like a blueprint. She wanted half of a $2,300,000 0 cents estate. Clean split, no negotiation, just business. What she didn't know is that I'd learned to read between the lines long before I learned to read contracts. Every missed visit, every excuse about being too emotional to help with Dad's care. Every time she'd volunteered to handle the boring financial stuff so I could focus on his medical needs. I'd been grateful. Thought she was protecting me from extra stress. Turns out she was protecting herself from extra witnesses. The house felt different now, quieter, not the kind of quiet that comes from being alone, the kind that comes from finally seeing clearly. I walked to my home office and pulled out my father's estate file, 3 inches thick, trust documents, beneficiary forms, asset schedules, all the paperwork I'd helped him organize 5 years ago when Mom died. Susan had been there for those conversations too. Asked good questions, took notes, said she wanted to understand in case something happened to David. Smart woman, just not smart enough to understand who she was playing against. I opened the file and started reading, not as a son mourning his father, as a professional reviewing a case. Because that's what this was now, a case. Susan thought she'd married an estate planner. What she'd actually married was someone who'd spent 2 decades watching families destroy each other over money. I knew every trick in the book. Hell, I'd written half the playbook. The funeral program lay beside the divorce papers. 2 documents, 2 endings. One I couldn't change, one I could. Maybe I'd seen the signs all along. Maybe I'd just chosen to call them something else. Grief doesn't need time when it's replaced by pattern recognition. A sympathy casserole was still warm when I saw the first transfer receipt. Mrs. Patterson from next door had dropped off her famous tuna noodle dish that morning. I was heating it up when I opened Dad's banking folder and found the statement tucked between 2 insurance policies, a $42,000 0 cents check, written 6 months ago to something called Meridian Care Solutions, LLC. I'd never heard of the company, but I recognized the account, the one Susan had insisted Dad opened for easier estate management. The signature looked wrong, too neat. Dad's handwriting had gotten shaky in his final year, but this looked like someone had traced it, someone careful, someone who'd practiced. I set the casserole aside and spread the bank statements across my kitchen table. 3 months of transactions, all small withdrawals at first, then bigger ones, always signed in that same careful handwriting. 22 years in estate planning teaches you to spot patterns. This wasn't confusion or cognitive decline. This was systematic. I needed a second opinion, someone who wouldn't ask questions I wasn't ready to answer. Claire Williams worked as a junior associate at Meridian Trust. Quiet, competent, and sharp enough to catch details others missed. We'd worked together on several family trusts over the years. She also handled the administrative side of Dad's estate setup. I called her office at 8 the next morning. "Claire, it's David Mercer. I need to review my father's trust documents. Can we meet today?" "Of course. I'm sorry for your loss, David. Your father was a good man." She didn't know how good, or how vulnerable he'd become. We met at her office downtown. Claire had everything ready. Trust documents, beneficiary forms, amendment records. She laid them out like evidence at a crime scene. "What exactly are you looking for?" she asked. I showed her the bank statement. "This transaction. Can you tell me when the account was authorized?" She pulled out a form dated 8 months ago, Susan's signature at the bottom, along with a power of attorney document. "She said you were too busy with his medical care to handle the financial details," Claire explained. "Wanted to make things easier for everyone." Easy. Right. Claire studied the check amount. "That's interesting. This account was supposed to be for care expenses only, medical bills, nursing assistance, things like that." "What's Meridian Care Solutions?" She pulled up her computer, searched the business registry. "Incorporated 7 months ago, single member LLC. Registered agent is," she paused, "Susan Mercer?" The room went quiet. Claire looked at me, then back at her screen. "David, there's something else you should know about the trust modifications." She pulled out another set of documents. Trust amendments dated throughout Dad's final year. Small changes. Beneficiary adjustments. Power of appointment revisions. "These weren't part of the original structure you helped set up," Claire said carefully. "Someone added protective clauses for external threats. I knew that language. Dad had been a careful man. Paranoid even about family money disappearing to the wrong people. But these changes were recent, and they required trustee approval." "Who authorized these amendments?" I asked. Claire flipped through the pages. "According to this, your father did, but David?" She showed me the signatures. "These don't match the handwriting on his original documents either." The pieces were falling into place. Not the picture of a grieving widow overwhelmed by loss, the picture of someone who'd been playing a longer game. "There's more," Claire continued. "The trust structure changed fundamentally 6 months ago. It's no longer a simple inheritance vehicle. It became a conditional family trust." She explained what that meant without really explaining it. Dad hadn't died with a will. He died inside a legal fortress. And someone had been quietly changing the locks. My old office instincts kicked in. Clause review, asset flow tracking, power of appointment analysis. The trust had been altered, systematically, illegally. But here's what Susan hadn't counted on. I'd been doing this work since before she knew what a living trust was. "Claire, what happens if we can prove these amendments were made during cognitive decline?" "Legally challengeable," she said. "But it would mean a full probate review, court proceedings, public records, media attention if the estate is large enough." I thought about that. Dad had been a private man, worked hard, saved carefully, never wanted his business in the newspapers. A court battle would expose everything. His decline, the family dynamics. Susan's maneuvering. I didn't want noise. I wanted silence and finality. What about the protective clauses Dad built into the original trust? I asked. Claire smiled for the first time that day. Those are still active. In fact, they're stronger now because of the conditional structure. She pulled out a section I'd forgotten about, language Dad had insisted on years ago about external threats to family assets. If we can demonstrate misappropriation or fraud, the successor trustee can freeze all distributions pending review. Who's the successor trustee? Originally, it was going to be you. But according to these amendments, she checked the paperwork. It's now Meridian Trust itself, a corporate trustee with fiduciary responsibility. Susan had been busy, but she'd also made a critical error. She'd changed the beneficiary structure but left the protective mechanisms in place, like renovating a house but forgetting about the security system. What would you need to trigger those protections? I asked. Claire looked at the bank statements again. Evidence of misappropriation, fraudulent signatures, breach of fiduciary duty. We had all three. How long would the freeze last? Until the review is complete. Could be months. Could be longer if complications arise. I was no longer looking at a wife who'd left me. I was looking at a covert financial predator who'd timed her escape perfectly, except she hadn't understood the system she was trying to game. Claire, I need you to do something for me. Quietly. She nodded. File the paperwork to reassign successor trustee authority to Meridian Trust. Use the protective clause language Dad wrote for external threats. That will freeze all pending distributions. I know. Susan won't be able to access anything until the review is complete. I know that too. Claire began preparing the documents. David, once we file this, there's no going back. The trust goes into protective mode. I signed the authorization forms. That's the point. Susan thought she'd played the perfect game, timed her exit for maximum financial impact, filed for divorce while I was still processing grief. What she didn't know is that Dad had built safeguards into his estate plan, specifically for people like her, and she'd just triggered every single one. The paperwork was filed by 5 that afternoon. The estate was now under contingent management review. Susan had no idea the divorce meeting was scheduled. So I sent a reminder with a menu. Susan had suggested we meet at some neutral coffee shop downtown. Keep things civil, she'd said in her text. The only communication I'd received since she'd left. I had a better idea. Let's use the conference room at Meridian Trust, I replied. More professional, more private. She texted back within minutes. Perfect. Can I bring my lawyer? Of course. What she didn't ask was who else might be attending. Claire had everything prepared by Tuesday morning. Documents organized in labeled folders. Conference room reserved. Fresh coffee brewing in the lobby. We weren't planning to argue. We were going to let the structure speak for itself. Are you sure about this approach? Claire asked as we arranged the materials. Susan likes to control conversations, I said. Hard to control what you don't see coming. The corporate trustee arrived at 9:30. James Morrison from Meridian's fiduciary division. Gray suit, leather briefcase, the kind of professional demeanor that made you sit up straighter. He'd never met Susan. That was important. She walked in at exactly 10 o'clock, wearing confidence like expensive perfume, navy blazer, pearl earrings, the smile she used at neighborhood parties. Her lawyer followed behind, a young guy in an ill-fitting suit who looked like he'd graduated law school last week. David, she said warmly, thank you for being reasonable about this. I stood up and gestured to the chairs. Coffee? That would be lovely. I poured her a cup from the service Claire had set up. Added cream, no sugar, just how she liked it. I think we can work this out quickly, Susan continued, settling into her chair. The estate is straightforward, simple 50-50 split of marital assets. Her lawyer opened his notepad, started writing before anyone had said anything worth recording. That's when James Morrison walked into the room. Susan's smile flickered. I'm sorry, who's this? James Morrison, he said, setting his briefcase on the table. Corporate trustee for the Mercer Family Trust. He didn't shake hands, just opened his briefcase and pulled out a thick folder. I'm here to deliver a change of status notification regarding the estate of Harold Mercer. Susan's coffee cup stopped halfway to her lips. Morrison began reading from a prepared statement. Legal language, fiduciary responsibilities, trust modifications and protective clauses. The key phrase came 3 paragraphs in. All pending distributions are hereby frozen, pending comprehensive review of potential misappropriation. Susan set her coffee down slowly. I'm sorry, what does that mean exactly? Morrison looked at her like she was a stranger asking for directions, which, in a way, she was. It means the estate assets are no longer accessible to potential beneficiaries until the review process is complete. But I'm his wife, Susan said. I have marital rights, too. Actually, Morrison interrupted, the assets in question were retitled into a conditional family trust structure approximately 5 years ago. They're not governed by standard spousal access laws. He slid a document across the table. Trust amendment forms, beneficiary restrictions, conditional disbursement requirements. Access to trust assets requires demonstration of moral stewardship and care toward the grantor during his lifetime. Susan stared at the paperwork. Her lawyer leaned over to read along. I said nothing, just watched her process the information. Morrison continued. We've conducted a preliminary audit of care expenses charged to the family account. That's when I slid my own document across the table. A ledger of withdrawals from the account Susan had insisted Dad open. $7,200, 0 cents, in caregiver reimbursements, I said quietly. Interesting receipts. Susan's face went pale as she read through the entries. Spa treatments, personal training sessions, a weekend getaway to Wisconsin, all charged to Dad's care account while he was dying in a hospital bed. Those were stress expenses, she stammered. Taking care of someone with dementia is exhausting. You needed a massage therapist named Kevin, I said, twice a week for 3 months. Her lawyer looked confused. Susan looked trapped. Claire chose that moment to speak up. There's also the matter of the notary incident. She slid an affidavit across the table. A sworn statement from Patricia Wells, the notary Susan had approached about backdating signature authentication on trust documents. Ms. Wells was uncomfortable with the request, Claire explained. She filed a report with the state licensing board. Susan's composure cracked. This is ridiculous. David, you can't seriously believe. I don't believe anything, I said. I just reviewed documentation. She stood up suddenly. This is harassment, financial abuse. I'll go public with this, David. I'll tell everyone how you're using legal technicalities to steal from your own wife. That got my attention, not because of the threat, but because of what it meant for our daughter. Megan was 26, just starting her career as a teacher. She didn't need her mother's drama following her around. You want to go public? I asked. That's your choice. Susan smiled, thinking she'd found leverage. I will. I'll make sure everyone knows. Before you do that, I interrupted, you might want to look at this. I opened my own folder and pulled out a manila envelope. 8 by 10 photographs. Susan and Kevin, the massage therapist, leaving a hotel in Milwaukee, holding hands in a restaurant. Very cozy for a professional relationship. Her lawyer stopped writing. I never cared about the affair, I said calmly. But the trust document has specific moral clauses about beneficiary conduct. Fraud invalidates any claim to assets. Susan sank back into her chair. Here's what's going to happen, I continued. You have 2 options. Option 1, we go through a full probate review. Public records, court proceedings, every transaction questioned, every relationship examined. I gestured to the photographs. Kevin will probably have to testify about the nature of your business arrangement. Or, she whispered, Option 2, you sign a sealed settlement agreement. Clean break, no public mess, no media attention, no impact on Megan. Her lawyer finally spoke up. What are the terms? I slid the final document across the table. Complete waiver of any claim to the Mercer family trust, past, present, and future. In exchange, you keep the house and your personal accounts. That's it? Susan asked. That's it, she laughed. Actually laughed. You think I'm going to walk away from $2 million? I think you're going to walk away from a fraud investigation. Morrison cleared his throat. Ma'am, I should mention that trust misappropriation is a felony. The state attorney's office takes these cases very seriously. The laughter stopped. Susan looked at the photographs again, then at the notary affidavit, then at the care account receipts. She was doing the math, not the financial math, the risk assessment. 2 years in prison versus walking away clean. Where do I sign? She asked quietly. I handed her a pen. She signed every page without reading them. Her lawyer witnessed each signature with the enthusiasm of someone attending his own execution. Pleasure doing business with you, I said as she gathered her things. Susan paused at the door. You planned this whole thing, didn't you? No, I said. You did. I just read the fine print. She left without another word. Morrison packed up his briefcase. The trust assets will remain frozen until the settlement is officially recorded. How long will that take? 72 hours? I shook his hand. Thank you for your time. After they left, Claire and I sat in the empty conference room. The coffee had gone cold. Think she'll honor the agreement? Claire asked. She doesn't have a choice. Some people play checkers, others play chess. Susan had been moving pieces around the board for months, thinking she was winning. She never realized she was playing against someone who wrote the rules. She said nothing as she left, but her lawyer kept staring at the floor. The conference room door closed with a soft click. Susan's footsteps echoed down the hallway, getting fainter until they disappeared completely. Her lawyer had packed up his notes without making eye contact, just mumbled something about reviewing options, and followed her out. There were no options left to review. Morrison finished his paperwork with the efficiency of someone who'd done this before. The settlement will be recorded by Friday, he said. But there's one more step. He pulled out a standard form. IRS notification requirements for trust misappropriation cases. Federal law requires us to report irregular activity, he explained. The care account withdrawals trigger an automatic review. I nodded. How long does that process take? Depends on their caseload. Could be 6 months, could be longer. Susan's silence was now legally binding, but her problems were just beginning. The IRS doesn't care about sealed settlements or family drama. They care about tax fraud and asset concealment. Kevin, the massage therapist, was about to get some very interesting questions. I drove home through downtown traffic, thinking about the next phone call I'd have to make. Megan deserved to know what had happened. Not everything, but enough. She'd always been close to her mother. This was going to hurt. That evening, Claire called with an update. The trust modifications have been processed. Susan's name has been removed from all associated entities. Any pushback? Her lawyer filed a complaint with the State Bar Association, claims procedural irregularities. I wasn't surprised. What did the board say? They rejected it, based on clause precedents. The protective language in your father's original trust takes priority over any subsequent amendments. Dad had been smarter than I'd given him credit for. Even in his decline, he'd understood the importance of safeguards. There's something else, Claire continued. I've been reviewing the timeline of trust modifications. She'd found something. I could hear it in her voice. The First Amendment was filed 14 months ago, before your father's official dementia diagnosis. That stopped me cold. What kind of amendment? Beneficiary restructuring, power of attorney expansions, access privileges for quote-unquote care coordination. The timeline shifted everything. Susan hadn't been reacting to Dad's decline. She'd been preparing for it. She knew, I said quietly. Looks that way. The medical records show his first memory assessment was requested by her, not his doctor. Susan had orchestrated the entire sequence, got him tested, used the results to justify financial controls, then systematically moved assets while positioning herself as the devoted caregiver. It wasn't impatience, it was predation. I thought about all those evenings she'd spent helping Dad with paperwork while I was at work. All those bank appointments she'd volunteered to handle. She'd been hunting long before the prey knew it was wounded. The phone rang 3 days later. Megan's number. "Dad, can we talk?" Her voice sounded different, smaller. "Of course. What's going on?" "Someone from Claire's office dropped off some papers. Said you asked her to give me a summary of Mom's situation." Claire had done exactly what I'd asked, provided just enough truth without overwhelming details. "I wanted you to hear it from me," I said, "not from lawyers or court documents." Silence on the other end, then a quiet breath. "I didn't know, Dad, about any of it." "I know you didn't. The care account, the trust changes. She never told me she was..." Another pause. "I visited Grandpa every week. She barely came twice a month. Your mother made her choices, Megan. They don't reflect on you." But I defended her. When people asked why she wasn't around more, I made excuses. Said she was handling the financial stress so you could focus on his care. That hurt more than the divorce papers had, knowing that Megan had been covering for Susan's absence while Susan was systematically looting Dad's accounts. "You were being loyal," I said. "That's not something to apologize for. What happens now? Now you focus on your life, your teaching, your future. The rest of this is just paperwork." We talked for another 20 minutes. She asked careful questions. I gave careful answers. When we hung up, I realized something had shifted. Megan wasn't asking about her mother's side of the story anymore. Susan called her 2 weeks later. I know because Megan told me about it afterward. Said her mother had sounded different, smaller. "She's moving into a one-bedroom condo in Naperville," Megan explained. "Asked if I could help her move." "What did you tell her?" "I said she should ask you." The irony wasn't lost on either of us. Susan had spent months positioning herself as the primary caregiver while avoiding actual care responsibilities. Now she needed help, and the person she'd betrayed was the only one with resources to provide it. "Is she going to ask?" Megan wondered. "No," I said. "She's not." I was right. Susan never called. Instead, I heard through neighborhood gossip that she'd hired movers and handled the relocation herself. Downsized, from our 4-bedroom house to a rental unit with a Murphy bed and a galley kitchen. The condo was nice enough, clean, safe, affordable on a secretary's salary, which is what she'd be living on now that the settlement had eliminated any claim to family assets. Mrs. Patterson mentioned seeing her at the grocery store. "She looked tired," she said. "Asked about you, though." "What did you tell her?" "That you were doing well, keeping busy with work." Susan had bet everything on a financial strategy that required my father's death and my grief. She'd calculated the emotional variables like they were line items in a budget. What she hadn't calculated was the possibility that grief might be replaced by something more methodical. The IRS audit notice arrived at her new address 6 weeks later. I know because the letter was forwarded to our old house by mistake. I handed it to the mail carrier unopened. Wrong address. But I'd seen the return address. Internal Revenue Service. Criminal Investigation Division. Kevin was about to learn that caregiver reimbursements have very specific tax implications. Some people leave quietly. Others leave with consequences trailing behind them like shadows. Susan had chosen her exit strategy long before she'd filed the divorce papers. She just hadn't chosen wisely. A paperclip sat beside my father's pen. I never noticed it had rusted. 6 months had passed since the settlement. The house felt different now. Not empty, just mine again. I'd been avoiding Dad's old study, but today I finally walked in. His desk looked exactly the same. Reading glasses folded on top of a crossword puzzle. Coffee mug with a ring stain on the bottom. Everything frozen in time. I wasn't there to clean. I was there to close. The desk drawers held the usual accumulation of a long life. Receipts, warranties, business cards from people who'd been dead for years, nothing that mattered. Then I found the sealed envelope in the bottom drawer. My name written in Dad's careful handwriting, the paper yellowed around the edges. Inside was a letter dated 3 years ago, before the dementia diagnosis, before the trust modifications, before Susan had started her systematic predation. David, it began. If you're reading this, I'm probably gone, and you're probably dealing with the mess I should have cleaned up while I was alive. His words were precise, measured, the voice of a man who'd seen something coming, but hadn't known how to stop it. I saw something in Susan early on, a coldness that she hid well, the way she calculated relationships like investments. I chose silence because I thought maybe I was wrong. Maybe marriage would change her. He apologized for not speaking up sooner, for letting me learn the hard way about the woman I'd married. She's been positioning herself for years, son. Small moves, quiet adjustments, building access while appearing supportive. I tried to build safeguards into the trust, but I'm not sure they'll be enough. They had been enough. The letter ended with advice I wished I'd received 20 years earlier. Trust is earned through consistency, not claimed through proximity. The people who really care don't need legal documents to prove it. I read it once, then folded it carefully and put it in my jacket pocket. Dad had known, had tried to warn me without saying the words directly, had built protections into his estate plan like a father leaving breadcrumbs for his son to follow. The irony was perfect. Susan had spent months trying to outmaneuver a dead man's legal strategy, never realizing she was fighting someone who'd understood her nature better than she understood it herself. I locked the desk and drove to the courthouse. The clerk handed me the standard forms for estate plan amendments. Simple paperwork, a few signatures. But this wasn't about complexity. This was about clarity. I added one clause to my own trust documents. Anyone seeking access to my assets would need to demonstrate active care and support during my lifetime. Not financial management, not proximity, not good intentions. Actual care. Documented, witnessed, proven. The amendment was filed by close of business, notarized, recorded, and legally binding. No one would have access again without proof of care. Walking back to my car, I thought about the difference between wills and warnings, between hoping people will do the right thing and making sure they have to. Dad had taught me one final lesson, not through conversation or advice, but through experience. Some people write wills, others write warnings. I prefer contracts.